Immigration attorney Michael Phulwani, and once again we have with us attorney David Nachman. So David, welcome.
Thank you, Michael.
And you must have watched the last program on Mitchell Ignatoff, who was talking about a very important subject. This is the Halloween time. Woo! I know it's scary because it's a scary program. You talk about the crimes and people getting to jail and people getting deportations out of this, but just take this in the spirit of happy Halloween, enjoy, and have the kids go out and,
get as much loot as possible.
And be careful.
And be careful.
Be
yes.
careful.
Be careful.
So let us come back to the subject of crimes and how they affect the immigration benefits from time to time. One just suggestion that I want to give my clients, and I'm sure both of you will join there, is that in our culture, many of the clients, people that come to meet us or David on immigration issues, applying for citizenship, applying for a green card or anything, they try to not talk about the crimes. I mean, they just feel embarrassed, or they feel, well, do I really have to? I did a small thing anyway. It happens quite often. I had a small 10 years ago, why unnecessarily bring this subject up? And I would say that in these times, when you have a Department of Homeland Security, the database, the computers, it will come up. You apply for citizenship and you are arrested, fingerprinted for anything is there. So if you lie, then you are creating one more problem for you. Not only your application may be denied, but you may be charged with not having a good moral character. That's something else that we talk about also today. But this is a good piece of advice. When you go to an immigration attorney, is there anything in your background, a crime or something, tell the attorney, and he can then guide you also. He can see whether there's a waiver available or not, or whether we can have the, what you call the post-conviction relief, and I'm sure Mitch is going to talk about that also. So you both join me in that advice?
Oh yeah, absolutely.
Okay.
Absolutely.
With that, back to you, Mitch.
Okay, well, I wanted to talk about two things. The first is having an attorney who's skilled, has some knowledge of immigration law represent you. Look, it's just a simple little...
I'm going to interrupt you.
Sure.
After this Padilla case, would you say that a large percentage of criminal law attorneys are aware of the Padilla case, that they do ask the clients and,
It's hard for me to say that. They're supposed to be.
They should be.
Now
right,
they should
exactly,
be.
Yeah.
There's no question that now they're legally obligated to be.
Right. The Supreme Court told them to.
That's right.
This advice goes further, not only to your immigration attorneys, tell about the crime that you have committed, but if there's a crime and you are also seeking immigration benefits, you should talk to the criminal attorney also. Tell him, by the way, I just want to tell you, I applied for green card, I will be applying soon, or whatever it is, and please make sure that whatever happens here in this case today is going to affect me.
Correct.
No, immediately then you put them on notice, the criminal lawyer. And he
Absolutely.
Right.
Yeah, that's good advice, right?
That's excellent advice.
Okay.
Yeah.
Because
It's best to know it up front because you can deal with it rather than waiting till the end and finding out, and then it becomes a surprise, and then you can't deal with it. That's
correct.
Sorry about interrupting you.
No, that's fine.
Yeah.
I think
Go ahead.
The thing is that I want to know, if I'm representing you, even for something as simple as shoplifting, and I want to know where you're going. Are you making some kind of application for citizenship? Are you making an application for a green card? What is it that you're doing? The idea here is that you want an attorney, now constitutionally required under the Sixth Amendment, but you want an attorney who's going to know what the immigration consequences are, or who knows attorneys that he can pick up the phone and ask them, what's the immigration consequence of this? The idea is to plead to something that if assuming that you are guilty, which we'll deal with some other time, but assuming that you are guilty of something, you want to arrange a plea so that you have as few immigration consequences as possible.
Exactly.
But if your client is a U.S. citizen, then you don't have to worry about
U.S. citizen, you don't have to worry about
immigration consequences. He said, I'm a U.S. citizen, forget about whatever happens under the law, that in a crime and punishment, and that's a criminal thing. He's not applying for an immigration benefit, so that really should not affect much.
That's right. Michael, I mean, probably like you do in your office, we tell people who have obviously accrued the appropriate amount of time and who qualify for naturalization to go ahead and do it as quickly as they can, because obviously that criminal issue is always looming out there for people who have green cards. I told you a story, I believe I had a client many, many years ago who was driving, he was a driver, a limousine driver, and he was called for a fare in Texas, and he was driving on his way to work to pick up the fare, and he hit a young lady and unfortunately killed her. At that time, there was a vehicular homicide statute, and they put him into a deportation, and they deported him.
Right.
And so it was very quick. He qualified for citizenship. I told him for 10 years to apply for citizenship. He never got around to doing it. So things can happen by accident that could affect a person if they have their green card and don't apply for naturalization. So if you qualify for naturalization, definitely go for it.
So one other advice is that if our viewers, that if you are a green card holder and eligible for applying for naturalization, but a lot of people are lazy and they're so, why do I do it? Is it required for me? I have no reason. I have no benefit of becoming a citizen. This program gives you some idea about that. That listen, remember, you are an alien, you are an alien, you are an alien. A green card holder is an alien under the immigration law. And these kind of consequences come from a crime. Also, you can be deported. Even your green card holder, your green card could be taken away, and we can talk about that also. Not just for people who are illegally here, it's for everybody here.
Correct.
But if you are a U.S. citizen, of course, the law will take its own course, and you may have a penalty or a punishment, whatever. But nothing to do with your immigration consequences. That's another good reason for people who are eligible to become citizens.
In other words, if you become a citizen, you can't be deported.
No issue.
You're not subject. There's no issue about immigration law at all.
Nothing to do with your subject. It's you are a citizen. People ask, can I go and live in India 10 years, 20 years for the rest of your life? There's no requirement that like a green card holder, you go more than a year, you may lose the green card. Or you are a green card holder, you come back and forth all the time, and the CBP at the port of entry gives you errors, tell you, listen, I don't think you are living here, I'm going to take away your green card. All these problems will disappear.
Right.
Correct.
Or they stop them at the port of entry and they say, oh, we noticed that you have a crime, because they have access to the CIC, which is the criminal database, and they say, oh, well, we don't know what that crime is, because they can't figure it out from the database. All they know is there's a crime. So what they do is they ask you to come down to the CBP, to the port of entry, and to show the disposition to see whether or not it's a crime that excludes them, makes them inadmissible to the United States.
Even if the person was only arrested and not convicted, but there's information.
There's something in the database.
Exactly.
The CBP doesn't know what it is. They only know it's in the database. But Mitch, let's go back to, okay, so you talked about getting the best possible result that you could under the circumstances for an individual and letting them plea. What happens if, notwithstanding everything you've tried to do for them, they take a plea, but it's going to hurt them immigration-wise? Is there something that can be done later on to help them out? And I'm getting to post-conviction relief.
Same
so tell us a little bit about post-conviction relief. And how can you help the viewers that way?
The Padilla versus Kentucky really is a case about post-conviction relief. What
was the issue?
Well, the United States Supreme Court held that criminal trial counsel was incompetent if they did not advise of the immigration consequences of a guilty plea.
Correct.
Now, there's a controversy about how far back you can go. My reading of the case means that you can go back all the way at least until 1986, perhaps even further back, so that if you were convicted any time from 2010 back to 1986, you can bring what's called an action for post-conviction relief in New Jersey. In New York, it's called a Rule 440 motion, to get the conviction vacated in order, because you weren't advised of the immigration consequences.
If I interrupt you for our viewers, because they may not understand the words post-conviction, basically what you are telling our viewers is that if a person has been convicted for a crime, that is going to affect his immigration benefits. But you are saying that even if that has happened, it is possible in some cases that you can go back to the same criminal court and you can further and request the judge to change the nature of conviction to a lesser degree or a different type of crime.
Well, I wouldn't go that far. Okay. What it does is if you successful challenging the conviction, it reopens it. That's all it does.
Okay.
It reopens it so that you're still charged. But very often, because of the time passing, or I often have circumstances where clients, they better themselves.
So what happens after reopening?
And so the prosecutor may look at what happened from like 1986 till today and say, well, this guy's a good guy. I'm going to dismiss it.
So you can prove rehabilitation.
You can prove rehabilitation under many circumstances.
After reopening, it's just like the judge entering a new decision.
Correct.
It could be even an acquittal.
Could be.
It could be reducing the penalty, changing the law under which the crime conviction took place.
You can engage in plea bargaining again, is what that means from
And what
from
is
a
your
criminal
experience,
perspective.
Mitch, if I'm asking?
My experience so far has been that you can be very successful because, often the state's not interested in pursuing the case. And if you can show, for instance, the person screwed up 15 years ago, but since that time they've been a taxpayer, they haven't gotten in any trouble with the law, they're employed, they're raising a family. Very often the state will say, we don't care. Dismiss it.
It's very interesting, Mitch, that you say that, because I'm thinking that a lot of these very serious federal crimes are a result of maybe a U.S. attorney going after a big case for some political, exposure, and after, let's say, 15 years, obviously they don't have that need anymore. So maybe their interest in that case is sort of waned. So that introduces a new opportunity for someone who maybe is going after post-conviction relief, not to necessarily be in the limelight. So you might be able to get a good result for them that way.
I might. You got to understand there's another step to this. It's important to understand that you have to not only show that your attorney didn't behave in accordance with what the standards are, but you have to show some kind of prejudice to you. These days, at least in the Third Circuit, the court's pretty much decided that if you would have rationally made a decision to go to trial rather than simply accept a plea, that's enough of a prejudice for them to vacate the conviction.
Okay.
But it has to be some rational basis to go to trial, so that, if no matter which way you cut it, you're going to be found guilty, the court may not find prejudice and may not vacate the conviction.
Well, could the prejudice be that the individual didn't understand what the ultimate implication was going to be for immigration purposes?
That's only half of it. You have to prove it's under a case called, United States Supreme Court case called Strickland versus Washington. You have to show, first of all, that there was incompetence of counsel, but then you have to show that there was some kind of prejudice to you. That is, you would have gone to trial if you'd been advised of the immigration consequences, because you would have taken your chances with a jury to see, maybe a jury wouldn't convict you even, no matter what the facts.
Right, because the issues were so critical.
The issues were critical then.
Yeah.
Mitch, very good information. I'm sure most of our viewers will really, really appreciate for all this information that you are providing to them. And we thank all the viewers for watching the program. I'm sure that some of you, at least, who had similar problems, or you have friends or relatives who might have had these kind of situations, can be guided properly. And if you have any questions, comments, or suggestions, you can write to us. We'll be more than happy to respond. David, Mitch, both of you, thank you very much.
Thank you.
Thank you, Michael. And everyone have a happy Halloween.
Very happy Halloween.
Trick or treat. Goodbye.